Good afternoon. My name is Sheila Lamb, and I'm with the Virginia SBDC Network. For those of you that are not familiar with our organization, the Virginia Small Business Development Center is a partnership program between the U.S. Small Business Administration, George Mason University, and local host institutions throughout Virginia. With 26 locations across the Commonwealth, we provide training and technical assistance to small businesses in their local communities. Our one-on-one advising services are available at no charge. Today's webinar, Patent Basics, is presented by the Virginia SBDC Network in collaboration with the U.S. Patent and Trademark Office. Be sure to check out the next webinar in this series, Trademark Basics, on April 28th, and I'll drop that registration link into the chat momentarily. We are recording today's presentation, and it will be posted on our website, virginiasbdc.org. Due to the expected large number of participants, everyone's microphone is muted and the chat feature is turned off. But if you have questions during the presentation, you can type those into the Q&A box and we will adjust them time permitting. We have also enabled the live transcript function, which you can show or hide via your own meeting controls. And now it is my pleasure to introduce our presenter for today's session, Elizabeth Doherty, the Southeastern Regional Outreach Director for the U.S. Patent and Trademark Office, the USPTO. Elizabeth carries out the strategic direction of the Under-Secretary of Commerce for Intellectual Property and Director of the USPTO, and is responsible for leading the USPTO's Southeast Coast stakeholder engagement. She has more than 25 years of experience working at the USPTO. Elizabeth has dedicated much of her career to the USPTO's outreach and education programs, focusing on small businesses, startups, and entrepreneurs. In this effort, she has developed, implemented, and supervised programs that support the independent investor community, small businesses, entrepreneurs, and the intellectual property interests of colleges and universities. Similarly, Elizabeth has spearheaded a number of special projects with federal, state, and local governments and private organizations to promote and support invention and innovation in the United States. Focusing on the Southeastern region and actively engaging with the community, Elizabeth ensures the USPTO's initiatives and programs are tailored to the region's unique ecosystem of industries and stakeholders. Please join me in welcoming Elizabeth Doherty.
Thank you, Sheila. It is always a pleasure to be on with you, your audience, and the Virginia SBDC community. And of course, it's always great to be on talking about one of my favorite topics, intellectual property. So today we've come together to do a little bit deeper dive into patents. Many of you, and I hope all of you, may have previously attended the Intellectual Property Fundamentals or Intellectual Property 101 course that was taught, where in that course, it was a survey course of the 4 basic types of intellectual property: patents, trademarks, copyrights, and trade secrets, what their role is, what their durations are, and what purpose they serve in protecting creativity, invention, and innovation. Well, today we're going to take that next step and we're going to look more specifically at the world of U.S. patents. So I've got a whole host of materials for you and I'm excited to share them. So let's go ahead and jump right into our slides. So what are we going to talk about today? We are going to talk about the contents of a patent application. And our conversation is in the context of filing a U.S. patent application. We won't talk today about international patent filing, although that's certainly a topic of interest and importance. We're going to talk about the parts of a patent application. What is the enablement requirement? What are you required as an applicant to provide? Limitations of claims. You may have heard the term patent claims. Claims are the name of the game, I'll tell you right up front. And that it is important to capture your invention using clear and consistent language throughout the entirety of your disclosure. Now, what does this all mean? Well, we're going to find out together. Today, our conversation is going to focus primarily on utility applications. Now, with that said, and bouncing back again to our Intellectual Property Fundamentals course, you may remember that the U.S. has 3 types of patents: utility, design, and plant. Utility, again, what we're going to speak about today, cover mostly what we think of as inventions. A new toothbrush, a new cellular communication device, a new mousetrap. They are good for 20 years from the date of earliest filing and have a lot of parts and pieces, which we're going to talk about very specifically. Design patents protect the ornamental appearance of an article of manufacture. Those are good for 15 years from the date of issuance. And then our beautiful plant patents protect any asexually reproduced plant, flowering tree, shrub, and those are good for 20 years from the date of issuance. But again, today our focus is going to be on US utility patent applications, which in all likelihood is probably what you're considering filing. Now, with that said, we shouldn't diminish the concept of having an IP portfolio where you may have multiple forms of intellectual property protecting your invention, innovation, creativity, or in fact, brand. That intellectual property portfolio might contain all of patents, trademarks, copyrights, and trade secrets. I'll leave it up to you to decipher which ones you need. So when we talk about utility applications, there are two types. There is the provisional patent application, which is not examined or published. It serves as a one-year placeholder with the US Patent and Trademark Office, is only available for utility applications, and allows you to get something on file with the US Patent and Trademark Office for a low cost of entry and a low barrier of entry, and lets you begin to use the term patent pending. The provisional patent application, note that I didn't say provisional patent, the provisional patent application can be an incredibly useful tool for someone who is getting started and wants to get something on file quickly with the office. Again, low cost of entry, low barrier of entry, and it allows you to begin using that term patent pending. The word of caution, though, is that it is only good for 1 year. So it is that placeholder that if you do want to seek a US patent, you must file that non-provisional. It's in the non-provisional, and what we're going to focus on today, that there are claims, a written description. It is also published at 18 months, unless you, the filer, specifically requests for non-publication. And ultimately, the non-provisional patent application can issue as a US patent. Now, I have to say, this is one of my favorite teaching examples here, the Snowman Accessory Kit, issued to Robert Kenyon in 1995. I think it's a delightful patent, which shows, I think, very vividly that not all patents are for complicated subject matter. Things of all natures are patented, and I think that'll come through in our conversation today. So when we talk about filing your US patent application, what's going to become quickly apparent is there is a lot of form and formality in filing a patent application. And I think in part that leads to the complexity, and one reason the majority of applicants use a patent attorney or a patent agent. Let's just start with the title of the invention. When identifying the title of your invention to file your patent application, it should be short and specific in describing the invention. It should be a technology-focused title. Think back to our Snowman Accessory Kit. That wasn't Robert's super duper winter fun patent. It was a Snowman Accessory Kit, a short, specific, technological title. Avoid generic language and allow a reader to readily ascertain what your invention is. Because keep in mind, the beauty of the US patent system is we have created the world's repository, the world's greatest repository of technological information. Your patent, whether you choose to commercialize your invention or not, is going to become a part of that technological disclosure that the world can benefit from today and even after your patent expires. So what is the specification of a US patent application? Well, the specification is where you tell the US Patent and Trademark Office for examination purposes and the public exactly what your invention is. It has the written description of the invention, telling specifically how to make and use your invention, because that's part of the quid pro quo of the US patent system. Now, what does quid pro quo mean? It means, translated from Latin, this for that, because the US patent system offers and empowers to inventors in exchange for them disclosing their invention to the public, that we shall issue them a right to exclude others from making, using, selling, offering for sale, or importing their invention for a limited period of time if we issue a US patent. That is the this for that, the quid pro quo. So in doing so, the US Patent and Trademark Office requires its applicants to file a specification with clear, full, concise, and exact terms to allow any person skilled in the technology of the invention to make and use the invention. There must be at least one specific embodiment, and it must conclude with at least one claim. But as you're going to quickly hear, and I'll say it more than once, for the basic filing fee, you're entitled to 3 independent claims and 20 claims total. Now, that may be sufficient for claiming your invention or not. There is no limit to the number of claims you can have, but above the 3 independent and 20 total, you will have to pay additional claims fees. So going back to a patent application having a requisite form and format, as you can see, the specification page format says that the abstract and claims and specification, the written description, must have lines that are 1.5 or double spaced in a single column of text, written on only one side in portrait orientation, 8.5 by 11. Now, this does tend toward or lean back to those days when most of our applications were filed in paper. Now, 99.9% of our applications come in today digitally, but they still must follow this requisite format. The application pages must be numbered consecutively using a non-script font. So what are some of the common sections of the specification? Now remember, specification translates to the written description of the invention and anything else necessary to describe the invention and how to make and use it. So the specification has a title, which we've already touched on briefly, and most commonly a background section, which kind of sets the stage for how things were prior to your invention. The brief summary of the invention, briefly stating what it is you have invented. The brief description of the drawings, if you in fact have drawings in your application. And then a detailed description of the invention, where you will do a detailed description of what is found in the drawings, if you in fact have drawings. The claims of the application begin on a separate sheet and have a very set format, which we're going to go through in depth. And then there is the abstract. If you think back to our snowman accessory kit, you saw that brief paragraph on the front page of the patent. The abstract is a short summary of the invention, kind of a thumbnail sketch of less than 150 words. Now, these lesser used sections, these may appear in a patent application if they are pertinent or relevant to you as an applicant. Cross-reference to related applications, if the application you are filing is related to a previously filed, perhaps it's a divisional application or a continuation in part application. Statement regarding any federally sponsored research, if you are in fact in that category. Names of parties to a joint research agreement. Incorporation by reference of materials submitted via a compact disc or text file. Statement regarding prior disclosure by the inventor or a joint inventor, and sequence listing, if that pertains to your technology. So let's do a little bit of a deeper dive on each of these most common sections, beginning with the background of the invention. So as I said before, it sets the stage for how things were before you filed your invention. It describes at a high level the areas pertinent to your invention, describes what you know has been done before, the problems that led up to you coming up with your invention, and potentially any prior art you know about. Now that last feature, what does that mean? Well, let's keep in mind, as an applicant, you have what is called a duty of disclosure. The duty of disclosure can be found at 37 CFR 1.55. You have a duty of disclosure to disclose to the office anything that is pertinent to the patentability of your invention that you are aware of. So perhaps you became aware because you did a prior art search, or perhaps you're an aficionado in the technology area and you read trade publications all the time and you saw something that helped to spark your idea and is relevant to your invention. You have a duty of disclosure to file with the office any prior art that you know about. And I'm sorry, I believe I said 37 CFR 1.55. It's actually 1.56. Rule 56, the duty of disclosure. Don't forget. So what is the brief summary of the invention? Well, the brief summary of the invention is pointed directly at you. You've just had the brief description, the background brief description, where you set the stage. This brief summary of the invention is all about you and your invention, the summary of what it is you have done, describing at a high level your invention, describing the problems you solve using your invention, what makes your invention special or different, and describes what your invention does. Now, again, keep in mind, a patent is a technological disclosure. It's not a place to brag. It's not a place to storytell. We don't need to know that you were on your summer vacation riding on a boat when you came up with your new wind speed detector. We don't need to know that, although it's incredibly interesting and fascinating. That should not be part of your patent application. So how about the brief description of the drawings? Well, the title itself is pretty self-explanatory. If you are using drawings in your application, and you're required to use drawings if you have invented something that can be depicted in drawings, if those drawings are part of the application papers, this section needs to be provided before the application is considered complete and released from initial processing. What does that mean? Well, it means that when you file your US patent application, it goes to an area of initial processing, our Office of Initial Patent Application Processing, or OPAP. OPAP is going to pick up your application when it comes in the door, and they are going to review it for its completeness. It's only when they determine that it is complete that they will then forward it on to the relevant technology center, art unit, and patent examiner to have it docketed for examination. They're going to be looking for things like compliance with the laws and the rules. Does your application have all of the requisite sections and pages? Things like an oath or declaration, an application data sheet. Does your application have claims? Does it have an abstract? Does it have a title? Now, this section, the brief description of the drawings, must include a brief statement of what each figure depicts. Keeping in mind that if you have however many drawings you have, this section must reference each one of those drawings. So to do a greater discussion on the drawing section itself, it is part of the disclosure, part of your specification, and are required if necessary to understand the invention. Now, I will say over time, we have somewhat relaxed the drawing standards. In previous years, one was required to use the work of an official draftsman to draft your patent application drawings. We now recognize that there's so many tools out there for applicants to do it, whether it's a CAD drawing machine or again, the official assistance of a draftsman, that we have relaxed the standards of drawings. However, I think a word to the wise is because these become a part of your patent, it's certainly part of your patent application, but because they become part of your patent, which hopefully issues, I would urge you to use the highest quality drawings possible, even under the opportunity for a relaxed drawing requirement. They must show every feature of the invention as claimed, and must contain as many views as necessary to show the invention. You are not limited in the number of drawings you may provide, although because drawings are a part of your specification, there are page limits on the specification before you are charged additional fees. The basic filing fee for your patent application allows you to have a specification of up to 100 pages. Now, once you go above 100 pages, there will be additional fees. So with respect to your drawings, drawings should be black and white drawings with lines and numbers heavy enough to permit adequate reproduction. Now, again, this harkens back to our days of paper processing and reproduction, but still important in a digital footprint. One should use reference numerals, both in the specification and the drawings, and those need to correspond. Each figure must be labeled, and you should avoid using descriptive words in the figures. Don't actually place any text in the figures if at all possible. Now, we've already touched on the abstract, but let's circle back with all of the requirements. Remember, the abstract is that thumbnail sketch of what your invention is that is found on the face of your patent. Think back to that snowman accessory kit. You saw that brief description of what is a snowman accessory kit, or at least one as invented by Robert Kenyon. It starts on a separate sheet with the heading abstract and must be 150 words or less. Again, they have to be in a font that is non-script and 1.5 or double spaced. It is a narrative form, a single paragraph, but it can be multiple sentences, which isn't true of our claims, and you'll see that soon. It points out what is new in the technology and is not a repeat of the claims or the brief summary, although it and the brief summary do serve very similar purposes. It is written to enable the public to quickly determine the nature of the technical disclosure of the invention. Now, how about the detailed description of the invention? This is where you are really going to pour your heart out in writing as to how to make or use your invention. It's a very important part of the application, and this is where you teach the public, you teach others that are working in your field of technology, and you teach your competitors in such a way that they stay out of your space. You explain the invention and the process of making and using it in full, clear, and concise terms. You focus on explaining the structures, processes, or compositions of the invention. And this is where you will connect back with the drawings by referencing elements of the drawings, using the reference numerals to explain how the various parts within the drawings operate together or manufactured together, how they interact to solve or work as your invention. Continuing on with the detailed description of the invention, it should provide clear support or antecedent basis for all terms used in the claims. Now, what does that mean? Well, as I've said very early on, the claims are the name of the game. When we think about a piece of real property, and I know today we're talking about intellectual or intangible property, but when we think about a piece of real property, let's say, for example, a deed of land, a piece of land that is described in a written description in a property deed. That property deed is going to set forth the metes and bounds or the limitations of the shape and size of the property. Claims in a patent application and ultimately a patent do just that. They set forth the metes and bounds, they set forth the content of what the inventor has patented, of what the inventor has invented and now seeks protection for. So when you describe in the claims your invention, it needs to correspond with the language which is in the larger body of the specification. You can't, in the body of the specification, be discussing basketballs when you get to the claims and discuss bicycles. This is one application which depicts one invention in both drawings in a written description, and in the claims, which bring it all home in a tight and legal fashion. So for some people, it's helpful if they draft their claims first and then go on to draft their written description. That's really a matter of choice. Some people do it one way, some people do it another. By drafting the claims first, you could decide on terminology to use in the specification and make sure it's consistent. You can also figure out which terms need to be defined in your written description. Claims can serve as a checklist in that fashion. So now that we've talked about the specification in great depth, let's talk about some specification do's and some specification don'ts. First and foremost, use the specification to describe the invention clearly, such that any person of ordinary skill in the art can make and use the invention without undue experimentation. You can't just tell us a little bit about your invention, you've got to tell us all about your invention. When referencing the drawings, be sure that each reference numeral is used for only one part, one element, one feature of the drawings, and that each reference numeral shown in the drawings is mentioned in the specification. Provide at least one specific embodiment, including the best one known to you at the time of filing. Make sure that there is a brief description of the drawing section. Provide proper antecedent basis for all of the terms in the claims. And bottom line here, focus on the technical features of the invention. Again, this isn't a place for storytelling. This isn't a place to brag about how great your invention is. This is a place to disclose it with technical terminology and substantial specificity as to how to make and use the technology. So how about some specification cautions or possibly don'ts? You should not use trademarks in the title or to describe a structure, particularly if a trademark is not your own. In the background of the invention section, you do not need to state how you came up with your invention. For example, I came up with it while jogging. Great storytelling, but we don't need to know. Avoid making claims of possible future success. This invention will sell and make millions, or this invention will revolutionize the field. While we certainly hope those things for you, this isn't a place to make that type of prophecy. Do not include a detailed description of the figures or refer to reference characters in the brief description of the drawings. That will take place in the detailed description. And do not forget to proofread your specification to look for grammatical errors. It's surprising how many patent applications we get in that have a substantial number of grammatical errors. And that can lead to confusion or misunderstanding during examination. It can also result in additional back and forths during the examination process as you try to correct simple things like grammar. We'd love for that grammar to come in clean and clear from the very beginning. So now what about those claims? I've been alluding to claims, the importance of the claims. The claims are the name of the game. So what are patent claims? Well, I'll tell you from an attorney's point of view, not only are claims the name of the game, but patent claims are where a patent attorney earns their bread and butter because they are written in such a way that sometimes they don't feel like real everyday language because they are language that is a technical disclosure. This is where the attorney is really going to work hard for you to find the sweet spot of how to claim your invention. While you're entitled to claim your invention as broadly as possible, if you claim it too broadly, you won't be able to receive a patent because it will read upon an enormous world of technology. Now, if they claim your invention too narrowly, it'll be easy for others to invent around you. So the complexity lies in finding claims that are in that sweet spot, that middle spot. So the claims define the invention and what aspects are legally enforceable. Oftentimes for patent examiners and patent attorneys alike, when they pick up a US patent or patent application, they look first to the claims to truly understand and appreciate what has been invented. They must conform to the invention as set forth in the remainder of the specification. Remember, there must be that continuation, the congruity between the language of the specification and the language of the claims. Terms and phrases used in the claims must find clear support or antecedent basis in the description so that the meanings of the terms in the claims are clearly understood. So going back to the conversation about the form and formality of a US patent application, you see it very substantially in the area of the claims. The claims must start on a separate sheet with the heading claim listing. They must be 1.5 or double spaced. Each claim is a single sentence, no matter how long it is, beginning with a capital letter and ending with a period. Each claim is a single sentence. For the initial basic filing fee, you are entitled to 3 independent claims and 20 claims total before excess fees. The claims are numbered consecutively in ascending order. Original numbering is preserved throughout the prosecution. So if you have claims, you start with claims 1 through 20, and then during an amendment process, during patent examination and the back and forth that takes place, you would continue, if you chose to add claims, you would continue to number consecutively 21, 22, 23, and so forth. So what are some of the US patent law requirements with respect to a utility application? Well, a non-provisional patent application must have at least one claim, particularly pointing out and distinctly claiming the invention. The claim may be written in independent or dependent form. We'll talk a little bit about what that means. In fact, a dependent claim refers to a claim previously set forth and then further limits the claimed invention. A claim in independent form incorporates by reference all of the limitations of the claim to which it refers. So this is where you'll see people start with an independent claim that has a significant breadth to it, and then have descending dependent claims, which really hone in on the features of the independent claim, making each one more specific as it goes. So when drafting claims, the challenge is to be in that middle spot, that middle invention spot where your invention is adequately claimed, but not too specifically claimed and not too generally claimed. So if your application is too broad, meaning that you have described in your claims with such breadth that it reads upon other technologies, you're going to find that it is not patentable. However, if your invention is described in the claims too specifically, it will not be valuable because others can invent around it. So let's do a couple of training examples. And here's one of which you think maybe the claim might be too broad, but let's take a look together. We see that someone has invented what looks like a vehicle. And that vehicle in claim 1, remembering that claim 1 is one claim. A claim is a single sentence starting with a capital and ending with a period. It claims, this inventor is claiming, a vehicle comprising a frame, a first and second front wheel, and a first and second rear wheel aligned and spaced behind the first and second front wheel, a seat connected to the frame, and a removable top portion made of cloth, wherein each wheel rotates and is connected to the frame. It seems like it pretty adequately describes that invention set forth on this slide, a vehicle with a frame and wheels and a seat and a top portion. The top portion happens to be made out of cloth. And there's a description of how it operates. The wheels rotate because they are connected to the frame. Now, is this claim too broad? I think we're about to find out. Well, how about the covered wagon? Let's try and read the covered wagon on a vehicle comprising a frame, a first and second front wheel, and a first and second rear wheel aligned and then spaced behind the first and second front wheel, a seat connected to the frame, and a removable top portion made of cloth wherein each wheel rotates and is connected to the frame. This is a great way in which to truly understand the breadth of claims and if a claim could be too broad. However, let's take another look at a claim that may be overly specific. Remember, we're looking for that sweet spot somewhere in between. So the inventor has now tried to claim their vehicle more specifically as a step away from being overly broad. So this time, the vehicle comprises a motor, a yellow frame, including a plurality of hinged doors, a first and second front wheel, a first and second rear wheel aligned and spaced, a seat connected to the frame, a plurality of glass windows connected to the frame, 2 red lights connected to the frame, 2 metal bumpers connected to the frame, and a removable top portion made of cloth, wherein each wheel is made of rubber. Now, yes, this claim no longer reads on the covered wagon. There's a lot of features being called out here that are not found within the covered wagon. However, is it going to be easy to invent around this claim? Well, this claim suggests that the frame must be yellow. What if someone invents this exact vehicle with a red frame? Would that be patentable? That's a question for a patent examiner. I would guess probably not, but let's not speculate. The inventor now claims a plurality of glass windows connected to the frame. What if instead of glass windows, someone used plexiglass for the windows, or perhaps even just transparent film? Would it still read upon this vehicle? Would it be able to be patented or to be produced with this while this patent is in force? Great questions. So before drafting your claims, answer these questions because this may help put you in the right mindset to do it and to do it successfully. Think about what is the invention? Not the world of invention, but what is your invention? What are the pieces and parts that make up the invention? How do those pieces and parts relate to one another? Do you have more than one invention? Are there multiple versions of each invention? It's also important to think strategically. What is it you are hoping to accomplish with your patent application, with your patent claims, and ultimately with your patent? You do want to obtain the broadest valid claim possible, and that's what you're entitled to under the law. Obtain claims with a variety of claim scope, and not just at the time of filing, but during prosecution. What that latter point means is that you will, as you file your patent application and begin to undergo the patent examination process, you will be engaging with patent office professionals, patent examiners, supervisory patent examiners, who are going to work with you to help refine your claims, particularly where they find patentable subject matter in your application. Because examiners are required, they are required to point out to you if they find patentable subject matter. They're required to find it and bring it to your attention. You should also ask yourself, are some of your claims likely to be filed to be patentable without amendment? It also comes down to a question of money in certain instances. As I mentioned previously, for your basic filing fee, you are entitled to 3 independent claims and 20 claims total. So for any independent claims in excess of 3, it is $120 per claim. For total claims in excess of 20, $25 per claim. So you can see where this can begin to add up. Now, with that said, you are entitled to as many claims as you find necessary to adequately claim your invention. We've had patent applications come in with 1 claim. We've had applications come into the US Patent and Trademark Office with 1,001 claims. So there is no one set amount, although I would say as a best practice, that 3 and 20 is a pretty good number. So when drafting claims, it's also to recognize that there is certain language that is regularly used. And that is can be broken down into the three basic parts or three main parts of a patent claim. First, the preamble or the introduction to the claim, basically setting forth what the invention is. A transitional phrase, generally either comprising or consisting of, and a body then reciting the elements of the invention which have been set forth in the preamble. These transitional phrases, consisting and comprising, comprising is most often used because it is the broadest. It can set forth that comprising the following elements, but potentially others. Consisting of, that language is usually deemed more close-ended. For a claim that says consisting of, it is limited to those elements that are set forth in the claim. So just as we did when looking at the specification, let's now also take a look at claim do's and cautions. Your claim should particularly point out and distinctly claim the subject matter regarded as the invention. This is what you are legally entitled to if your patent issues, if your patent is taken to court, if someone infringes upon you, if you are working to enforce your patent, it will be the language of the claims that is most significant. Not to say that the rest of your patent in the specification won't, but the claims are really, again, the name of the game. Consider drafting your claims first and then your specification based on terms used in the claims. Again, that's just one approach. Review both to make necessary additions and corrections so that claim terms find support in the specification. Remember that there must be a consistency between the language of the written description and the language of the claims. These must overlap. These must overlay one another such that there is no confusion between the two. Look at the claims and patents issued in your field of technology, particularly if you're just getting started in the world of patents. It can oftentimes be very helpful to look at others in your field of endeavor. Now, don't copy their claims, but perhaps see the language and terminology, the layout, the format, the information encompasses therein. Ensure each term has proper antecedent basis. This is for your claims, making sure there is that consistency between the claims and the specification. And think about what legal protection you need for your invention and tailor your claims accordingly. Claim drafting cautions. Do not use claims covering two statutory classes of invention, a widget and a method for using the same. Do not use terms inconsistently between the claims or the specification. Do not write multi-sentence claims. Remember, a claim, each individual claim is a sentence. Do not refer back to only a portion of another claim. Do not replace elements from another claim within a dependent claim. So let's bring home our conversation today with a reference to some of the support and resources available to you as an inventor, innovator, and creator. Resources and support available through the U.S. Patent and Trademark Office. And some of these you may have heard if you tuned into one of our previous presentations, but I think it's worth discussing them again. First of which is our accessing our free service. And I'll tell you, outside of filing a patent or a trademark application or keeping it in force or some of our petition fees, many of our services are available to you at no cost. And you can actually find all of our free services in a one-stop shop location by going to uspto.gov/free services. Our Inventors Assistance Center. This is one that I would want you to bookmark if at all possible. The Inventors Assistance Center, and my apologies, this is out of date. They are now only open till 6 p.m., but still open a substantial amount of time, Monday through Friday. They provide patent information and services to the public. The Inventors Assistance Center, or IAC, is staffed by individuals who have had 20, 30, 40-year careers with the U.S. Patent and Trademark Office who are still now on giving back to our stakeholders. They answer questions from individuals who are just getting started in the process, or perhaps already have their patent in hand and still have questions. So please don't hesitate to reach out by phone or, in fact, by email. We also have what we call our Patent and Trademark Resource Centers. This is a network of 102 and still growing public libraries located across the nation, where that library has one or more trained librarians trained in patent and trademark searching. Now, while they won't conduct a patent or trademark search for you, they will assist you in developing a high quality search, which you can then do on your own. They'll teach you how to use USPTO products and services for searching, as well as others that they may have available at their library. Again, you can see that they're located across the globe at publicly available libraries, whether it's a college or university or a county or city library. I'd be remiss if I also didn't talk to you about the USPTO Patent Pro Bono Program. As a result of the America Invents Act of 2011, Congress directed the U.S. Patent and Trademark Office to work with state and regional legal entities to stand up a network of patent pro bono programs. These programs are either state or regional, and they offer reduced costs or most often free legal services to financially under-resourced inventors. When you look at our map, you can see the one that covers your state or your region. And I encourage you, if you are financially under-resourced, to visit their respective program to find out what the requirements are. In general, the requirements to be able to take advantage of the Patent Pro Bono program is that you have an income under a certain amount, and that varies by geography. You have to show that you have some knowledge of the patent program, of what you're getting yourself into. And you can do that by either filing your own provisional patent application or by taking a course that's available online through our office. And you also have to have more than a mere idea. You actually, in fact, have to have an invention. These resources, while they're fantastic, they are somewhat limited because there's only a certain pool of pro bono attorneys. So we want to make sure that they go to those inventors who are truly financially under-resourced and have an invention which can help to start and grow a small business and ultimately create an industry. With that, I am going to close out these slides, leaving you with our social media handles where you can find us any day of the week. Let me see, I thought I also had my email in there, but I don't, but I'm happy to provide that.
We can make sure that's in the follow-up email, Elizabeth.
Oh, beautiful. I am going to stop sharing my screen and see if we have any questions today.
We don't have any at the moment, so I will put a shout out to everyone. We have 10 minutes to pick Elizabeth's brain. If you have any questions you'd like to post, let's see. So Elizabeth, it says, thank you for conducting this wonderful session on the critical topic of utility patents. Can you characterize the extent of the backlog of unexamined applications specific to utility patents?
That's a great question.
Like AI and software increase the volume?
So great question. And it is, I will say the backlog is something that's always been a part of US patent practice. And it's something that every administration is keenly aware of and works to draw down that backlog. And we've done it through a variety of ways, through both hiring additional firepower. Currently, we are hiring US patent examiners, bringing in new patent examiners almost monthly right now on a very regular cadence. But we're also looking for additional tools and efficiencies to make their job more efficient and to happen more quickly. Now, with that said, what is the backlog? Well, it starts with the fact that we receive over 650,000 patent applications each and every year. Those 650,000 patent applications come in on top of those applications that are already sitting waiting examination or undergoing examination. So at any given time, we have over 1 million patent applications here at the US Patent and Trademark Office. Now, with respect to checking on your specific application or how we're doing in a specific technology area, we do have something called a patent dashboard. We actually have a number of dashboards for the agency where we reflect information to the public about how we're doing in that given area, whether it's patents, trademarks, or our Office of International Policy and Affairs. If you were to go to our website and type in the word dashboard, you would quickly jump to the part of our website that has the various dashboards. If you go to the patents dashboard, you can see where we are with respect to first office action pendency and total pendency. And those are our two kind of counting points in the life of a patent application. First office action pendency counting how long has the application been sitting in at the US Patent and Trademark Office until it is picked up for a first examination. That right now is running somewhere between 18 and 24 months, depending upon the area of filing. Now, total pendency, the amount of time it takes from an application to hit the doors of our office and then issue as a US patent, or to perhaps be abandoned or go on to an appeal, that's running somewhere generally between 24 and 36 months. Now, this is all to be caveated though, with it depends on the technology area in which you're filing. If you're filing in an area of heavy filing, AI, cellular communication, the backlog can be more substantial because it's a hot area. It's an area of a lot of activity. Now, if not to disparage toothbrushes, but if you've invented a new toothbrush, the delay in examination might not be quite as substantial. I hope that helps answer the question.
I think that was a great detailed answer. Let's see. What about AI inventions? Can you patent AI?
So certainly AI is coming in a host of applications in every area of technology. Whether you've invented a new toaster or a new toothbrush, there is AI infused in all of these. I think we can all think maybe the last time we went and looked at appliances. Now we have refrigerators that are not just keeping our groceries cool or frozen. They're now alerting us when we need to buy milk, or maybe even reaching out on the internet to buy that milk for us. So there is AI coming in everything. Now, I will say with respect to AI, the US Patent and Trademark Office views an inventor's use of AI just as another tool, just as using a pencil, using a protractor, using a calculator. AI is a tool which our inventors are using more and more frequently. Now, can they file an application for an invention invented entirely by AI? The answer is no. The patent laws of the United States require that there be substantial human intervention in the creation of an invention. So yes, while one can use AI as a tool, you cannot solely have AI as the inventor, at least at this point in time.
Let's see. How do I make sure, verify if I fall under the low income category federally as well as regionally so we can take advantage of the volunteer attorneys?
Great question. And I think that's a question that can be navigated with one of the programs. So find the program that is in your area and come to them with your information, because you will be evaluated as an individual with an analysis of your particular situation. So I would actually try applying to the program in your area if you think you qualify, and let them be the ones that tell you you don't. Because it may also depend on the volume of work that they have. There are some pro bono programs, whether it's because people don't know they exist or the need isn't substantial, that they may be willing to navigate or negotiate some of the requirements.
Does the patent need to include the math of an invention? Can it be held as a trade secret?
And that's an interesting question, and I'm not sure if I know entirely what's being asked. You know, when we go back to the specification and the written description, again, they were required to disclose with specificity how to make and use. Now, does it come down to, I'm trying to think of a good example to even like try and reference it in a math context. Um, Certainly one is able to have trade secrets which are associated with a patented technology. But I guess I'd really need to know more. And this sounds like a good question to take offline.
Okay, great. So I'll ask that attendee if you can just follow up with Elizabeth after the email goes
Sure.
out. Let's see. Is it possible to trademark or patent a seasoning recipe?
So I love this. We actually have published a great deal in the area of recipes. Um, so technically, one can't patent a recipe, although there are patents on food products. Um, and one can't trademark a recipe because trademarks, if we remember back to the intellectual property fundamentals course, trademarks are the indicator of the source of goods and services. Now, one might be able to copyright a recipe. That would be recording that creative form of expression in a tangible medium, whether it's a recipe card or written down digitally. Although the question would arise, is there the requisite level of creativity? Is there a modicum of creativity in that recipe to constitute something that is copyrightable? So recipes can potentially have a patentable aspect to them, but if the ingredients are all known and it's merely a modification of the percentages of the ingredients, it's going to be likely that it's going to be tough to patent that.
Makes sense. We have another question here. I have a utility patent and applied for a continuation patent. How does that affect the original patent? Does it extend the patent protection?
So it will to the portion. So continuing and divisionals are interesting because they are what we call child applications that refer to a parent. Obviously, the relationship between the applications can be seen in that context, parent and child. A continuation or a divisional will carry forward some of the content of the parent application, but it generally provides an additional patentable feature, or it provides some extension of the original. Bottom line, one cannot extend a patent term. The patent term for a utility patent right now is 20 years from the date of earliest filing. Oftentimes I get the question, oh, my patent is about to expire. Can I renew it? And the answer is no, because that is part of the grand bargain with the United States, is that after a set period of time, that information becomes part of the public domain. So what one is doing in a divisional or a continuation child application, it's taking part of the known technology, but it must also add additional information, additional features.
You're right at time and you got through all the questions.
Well, fantastic. This is what success looks like.
So, do you have any last words of wisdom and I'll wrap us up?
Well, Sheila, just to say thank you. Thank you to the SBDC. The U.S. Patent and Trademark Office enjoys working with the SBDCs, recognizing that you have the pulse of the community. You are the last mile into the community, assisting particularly our small business owners. And so much of the intellectual property in our nation is coming out of small businesses. So I guess the final word would be just to let them know that the U.S. Patent and Trademark Office is here to help them, whether it's with patents, trademarks, and we don't want to be seen as a black box agency. So please don't hesitate to reach out. Come to one of our classes, come to our locations, reach out through our Inventors Assistance Center, Trademark Assistance Center. Let us help you walk the journey of invention and innovation.
Thank you so much, Elizabeth. I agree. We work well together. We love helping our small businesses, and I could see where, yeah, we're just a good team, right? So thank you again for presenting for us, and thank you to everyone who joined us today. As a reminder, you're going to receive an email with a link to both the recording and to the slides. If you would like to sign up for upcoming webinars or access recorded webinars, please visit virginiasbdc.org/training. These resources are designed to be used in collaboration with your local SBDC advisors. You can sign up for a free and confidential session by emailing help@virginiasbdc.org or via our website. And we hope to see you all at our next session. Take care, everyone.
Thank you.